How do you analyze a personal jurisdiction issue on a civil procedure essay? Well, if you're not sure what personal jurisdiction is, no problem. Pause the video here, go back and watch my video where I overview personal jurisdiction, then you're going to be ready to go here. But remember, in short, personal jurisdiction is merely a requirement that the civil court must meet in order to have the authority to adjudicate the rights and liabilities of a defendant, which basically just means that the court has got to have personal jurisdiction. To hear and decide the case, you're going to have to establish that the civil court has personal jurisdiction. How do you do that? This is going to be your analysis. There's two main parts you want to think about. Number one, you're going to have the traditional bases. Now, if any of the traditional bases are satisfied, the court automatically has personal jurisdiction. But if none of the traditional bases are satisfied, no problem. Court can still reach out using a state long-arm statute, reaching out of state defendants, so long as minimum contacts exist between the defendant and the forum state. So step two, you'll move on in your analysis to a discussion of minimum contacts, state long-arm, to determine whether minimum contacts exist between the defendant and the forum state. You're going to want to discuss general jurisdiction and specific jurisdiction. Finally, to wrap up your analysis, you want to make sure that the exercise of such jurisdiction, general or specific jurisdiction, does not offend traditional notions of fair play and substantial justice. This you could kind of think about as part 3 of your analysis. So, number 1, you'll start with the traditional bases. If any of those are satisfied, court has personal jurisdiction. If not, no problem. Come down, discuss state long-arm statute, whether or not minimum contacts exist between the defendant and the forum state. How do you determine that? General and specific jurisdiction. Finally, you wrap up with this discussion of traditional notions of fair play and substantial justice. Now, no problem. Don't worry about it. I know that's a lot to hear right now, but when you actually run through this and you practice some essays yourself, it's not so bad. But let's break each of these steps in the analysis down, starting with your first step, which will be a discussion of the traditional bases. So remember, if any of the traditional bases are satisfied, then the court is going to automatically have personal jurisdiction over the defendant. I want you to think about the traditional basis as automatic qualifiers. If any of those are satisfied, the court will have personal jurisdiction over the defendant, no question about it. So what are your traditional bases? Number 1, you have domicile. Number 2, you have physical presence. Number 3, you have consent. And number 4, you have waiver. Okay, so if any of these 4 things happen, again, the court is going to have personal jurisdiction over the defendant. Start with number 1, domicile. If the defendant is domiciled in the forum state, then that court is going to have personal jurisdiction over the defendant. Very straightforward. Remember, domicile is the place where you reside with an intent to remain indefinitely. It's where you live. So if I am domiciled in the state of New York, I can be sued in the state of New York. New York has personal jurisdiction over me. Very straightforward. Just remember, domicile is where you live, where you reside with an intent to remain indefinitely. Physical presence is a little bit more nuanced. This is a kind of weird rule, but if you are physically present in the forum state voluntarily under your own volition, and while you are there, you are served with process, notice of the lawsuit, then that forum is going to have personal jurisdiction over you. Sometimes we call this tag jurisdiction because it's like coming into the forum state and you get tagged with notice or service of process, and now the court has personal jurisdiction over you. You could be in the forum state for an hour, as long as you're there voluntarily and you're served with process, then you're going to be able to be hailed into that forum as a defendant. The court is going to have personal jurisdiction over you. Now, the one exception to this is if you're a plaintiff, you can't lure a potential defendant into the forum state by force or fraud. You couldn't call the defendant and say, hey, your child is sick and in the hospital in this state. You got to go there right now to see them. They need you. Of course, that defendant goes to that hospital and you're waiting there to serve them with notice. That stuff is not going to work. You have to be there under your own volition. If you're tricked or forced or defrauded into coming into the forum state and then you're served, that's not going to work. Consent, your third traditional base, is very straightforward. A defendant can always consent to the jurisdiction, to the forum. That can be expressed or implied by conduct. Waiver, again, this is pretty straightforward. Something procedurally to remember is that the defendant actually has to object for lack of personal jurisdiction. If the defendant wants to challenge the lawsuit based on lack of personal jurisdiction, the defendant has to raise that. They have to object for lack of personal jurisdiction. So with waiver, if the defendant fails to object and participates on the merit of the case, then he's going to waive his objection for lack of personal jurisdiction, which is the same as satisfying any of the other traditional bases. Once you waive your objection, you're at your SOL now. You can't then challenge personal jurisdiction later. So de facto, it's the same as being domiciled or physically present or consenting. You no longer have your objection to use. Now, interestingly, as a note, lack of subject matter jurisdiction cannot be waived. Lack of personal jurisdiction can be waived. And remember, you can waive personal jurisdiction by substantial participation on the merits of the case. So if you show up, make your general appearance, start participating, and you're a defendant, you're going to waive your objection for lack of personal jurisdiction. So important to note in practice, too, as an attorney, if ever you think that there might be an issue with the jurisdiction, especially personal jurisdiction, you want to raise that objection sooner rather than later, or you're going to risk waiving it and losing it forever. Okay, so this is all, though, step one of the personal jurisdiction analysis. If any of these four traditional bases are satisfied, then the court is automatically going to have personal jurisdiction over the defendant. Now, what happens if none of these traditional bases are satisfied? Don't worry, all of this, as always, will be below the video if you want to see it, so don't try to worry about writing everything down. But what happens if none of the traditional bases are satisfied? Then, no problem, court can still use a state long-arm statute to reach an out-of-state defendant. Here, under a state long-arm statute, if minimum contacts exist between the defendant and the forum state, then the court is going to have personal jurisdiction over the defendant. So what is minimum contacts? This is going to be the test under a long-arm statute. What is minimum contacts? Also, one quick note before I jump into discussion of minimum contacts. On a civil procedure essay, remember we started with the four traditional bases, and I said if none of those are satisfied, court can still reach out with the state long-arm statute and reach an out-of-state defendant if you have minimum contacts. Okay, but another important thing to note on a civil procedure essay is that even if you find that a traditional base is satisfied, which means the court automatically has personal jurisdiction of the defendant, you still want to discuss state long-arm statute and minimum contacts to make sure you're getting all of your points, even though from a real-life standpoint or logical standpoint, you're saying traditional base is satisfied, court has personal jurisdiction. In real life, yes, the analysis could end there. But on a civil procedure essay, to make sure you're getting all of your points, you want to make sure that you discuss a state long-arm statute, minimum contacts, and everything I'm about to talk about. Also in real life, though, it is always good practice. Even if you think you've established something and it's obvious, you always, for your client, would want to discuss other alternative ways you can come to the same conclusion. It's good practice. Get some practical lawyering here. So how do you determine minimum contacts? So how do you determine whether minimum contacts exist between the defendant and the forum state? You'll want to run through an analysis for both general jurisdiction and specific jurisdiction. But let's just start with general jurisdiction. How do you determine whether general jurisdiction is present? Well, if the defendant's contact or activities in the forum state is so systematic and continuous that he is essentially at home in the forum state, then the court is going to have general jurisdiction and personal jurisdiction over the defendant. One more time, if the defendant's activity in the forum state is so systematic and continuous that the defendant is essentially at home in the forum state, then the court is going to have general jurisdiction over the defendant. So here you want to look for standard operating procedures. Think of a company that produces some sort of widget. Let's say a paper manufacturer, a company that manufactures paper and ships those paper up and down the Pacific coast. So let's say we have a manufacturing plant based in California, manufacturing paper. And then they ship that paper with big 18-wheeler trucks up and down from Oregon to Washington and back down to California, up and down the Pacific coast. That manufacturing facility in California is going to have a lot of systematic and continuous activity. Think of any supply line, any manufacturing plant. I'm sure you've seen on TV documentaries and things how systematic and continuous all of those operations are. That is the ultimate systematic and continuous operation. Something like a manufacturing facility is actually in the forum. That is going to be activity that is so systematic and continuous that the defendant is now at home in the forum state. It's essentially at home in the forum state, which means the court has general jurisdiction, right? So once you establish, the interesting thing here, so think about that paper supply company or that paper manufacturer. They have a manufacturing facility in California. That means they're at home in California. That means as a defendant, they can be sued on any claim that even if it's unrelated to their contact with the forum state, even if that claim has nothing to do with the manufacturing of paper, because they're at home in the forum state. Their activity is so systematic and continuous, they're essentially at home, they can be sued on any claim, even if it's unrelated to the contact. So it could be a breach of contract action that has nothing to do with the manufacture of paper. And quite frankly, thinking about supply lines, the truck routes, if every day at 6 a.m. the same trucks are leaving the same stations with the same supplies and running the same routes systematically and continuously, arguably that would also be systematic and continuous activity. So they could be at home, California, Oregon, Washington. You could argue all of these things. Now, so that's general jurisdiction. And the important thing to remember with general jurisdiction is you can be sued on any claim, even if it's unrelated to the specific contact, even if it's not related to what is giving rise to your continuous and systematic activity. So like I said, it could be a breach of contract claim that has nothing to do with the manufacture of paper, but because you're at home, that's going to work. Now with specific jurisdiction, it's a little bit different. Specific jurisdiction is another way you can establish minimum contacts between the defendant and the forum state. There's going to be two elements here. We'll call it purposeful availment, and foreseeability. And I'll explain these two elements out in a second. But first, what's important to realize, because I see this bungled all the time, general jurisdiction, once you establish the defendant is at home in the forum state, can be sued on any claim. Specific jurisdiction, once you establish that specific jurisdiction exists, the defendant can only be sued on a claim that is directly related to the specific contact with the forum state. So imagine that we have a the same paper company, right? And they've got their supply lines that go up and down the Pacific coast. Their manufacturing plant is in California, but they ship that paper up to Washington and Oregon and in California. Well, let's say something happens out of the usual that's not systematic and continuous, where they would need to go to Arizona to get something. Maybe something on their supply line breaks. They need some important part, so they send one of their trucks to Arizona to go get that part. This is not systematic and continuous, right? This is a one-off kind of deal going to Arizona. But let's say that this truck, as it's in Arizona, the driver of that truck is not paying attention, negligently rear ends a driver in Arizona. So that driver in Arizona wants to sue the paper manufacturing company for negligence in the state of Arizona. Could he do that? Well, so your first element for establishing a specific jurisdiction is going to be whether the defendant purposefully availed himself to the benefits of the forum state. Here, obviously, using Arizona state highways, that paper manufacturer company, when that truck is using those public state highways, you're availing yourselves to the benefit of the state of Arizona. Was it foreseeable that the activities in the forum state could result in the defendant being hailed into an Arizona court? It's all about foreseeability. Yes, obviously, if you're driving trucks, big 18-wheeler supply trucks, and across state lines, it's going to be foreseeable that accidents can happen, that you could be hailed into court in Arizona in that event. Nothing with foreseeability there that would make specific jurisdiction out of the realm of possibility. So the question being, though, could the defendant be sued for negligence? Yes, because that claim arises out of the specific contact with Arizona. That action of the truck driving in Arizona and rear-ending another car, that is the actual specific contact that is giving rise to the action. So that negligence action could be brought under specific jurisdiction for gaining personal jurisdiction over the defendant, which is the paper supply company. Now, say that some other plaintiff sees that this paper company is being sued in Arizona, and they say, hey, I would like to sue them in Arizona. Say Arizona has some sort of plaintiff-friendly law regarding breach of contract claims. So another company wants to sue this paper manufacturing company for breach of contract. They can't do that in Arizona because that action is not coming from their specific contact with Arizona. Now remember, if they had a manufacturing facility in Arizona, they had systematic and continuous activity in Arizona, then they could be sued on that breach of contract claim. They're at home. They can be sued on any claim, even if it's unrelated to the contact that gives rise to the action. But for specific jurisdiction, that's not the case. But that's going to be your main things to think about with minimum context, guys. It's actually pretty simple. Just do a general jurisdiction analysis, whether the contact is so systematic and continuous that the defendant is essentially at home in the forum state. Then you want to follow up with a specific jurisdiction analysis. We're going to run through two elements: whether the defendant purposefully availed himself to the benefits of the forum state, and whether that was in a manner that was foreseeable that he could be hailed into court there. Run through those two elements. Now, if either of these are satisfied, general jurisdiction or specific jurisdiction, then you're going to have sufficient minimum contacts between the defendant and the forum state. So there will only be one step left after you've run through all of this. And once you've established that you either have general jurisdiction or specific jurisdiction, you want to discuss whether the exercise of such jurisdiction offends traditional notions of fair play and substantial justice. Now, this concept, whether the exercise of such jurisdiction offends traditional notions of fair play and substantial justice, comes from International Shoe v. Washington. This is one of your most seminal cases in civil procedure. Remember, in torts, you have pause graph. This is the pause graph equivalent in civil procedure, which is why on a civil procedure essay, we want to make sure we include this. It's giving a nod to your grader that, hey, I remember international shoe, I'm talking about this, give me my points, right? So what's interesting about traditional notions of fair play and substantial justice, and why this is a little bit more nuanced, is if you actually read international shoe, there isn't a direct discussion on exactly how to apply this concept. It's derived from the due process clause of the 14th Amendment. But in that opinion, the judges don't really give a clear way to apply it. They give very broad stroke concepts, and courts have grappled with that since international shoe, and lots of factors have been developed. And I'll list out all the factors, or at least most of the main factors you see crop up again and again from other courts. But here I just want to kind of discuss what this idea is and the main things to think about. And then I'll give you some actual factors that you can shoot through. But without, I think, a little bit of basis for that, you might get confused. So what you're really looking for here, okay, so once you've established general jurisdiction and specific jurisdiction, whether those exist, you're looking for whether the exercise of that jurisdiction offends traditional notions of fair play and substantial justice. So the very first thing that you want to look for here is wrongful conduct. Any wrongful conduct, anything that either party is doing, the plaintiff or the defendant, to avoid or induce jurisdiction. So obviously if the defendant, sometimes you see the word scampering, if the defendant is somehow scampering or doing something to avoid being hailed into that forum, that's clearly inefficient or wrongful, that's going to offend traditional notions of fair play and substantial justice. Likewise, if the plaintiff is doing something that is, trying to induce a plaintiff or is trying to induce a defendant into the forum, kind of what we talked about with physical presence under the traditional basis, you lie and say that the defendant's child is in the hospital to try to get him there, anything like that. All of that's going to be offending traditional notions of fair play and substantial justice. So the first thing you want to think about is wrongful conduct. And then once you do that, there's lots of, for lack of a better word, kind of fairness factors you want to consider. And the main ones are going to be, the easy way to remember is to think about the defendant's perspective, the plaintiff's perspective, and the forum's perspective. So with the defendant, you can say, defendant, you want to think about convenience. For the plaintiff, you want to think about whether their interest is proper. So just proper interest, question mark. In the forum, similarly to the plaintiff, does the forum have a legit interest in redress, in providing redress? So you'll want to think about, these are your probably three main factors you're going to see courts bring up again and again when discussing whether the exercise of either general jurisdiction or specific jurisdiction offends traditional notions of fair play and substantial justice. Number one, you want to think about the convenience for the defendant. Remember, personal jurisdiction is all about the defendant. If hailing this defendant into this forum is going to be so inconvenient, it's going to place such a burden on the defendant that it's truly unfair and it's got to be big, it's a high threshold here, then maybe that's going to offend traditional notions of fair play and substantial justice. The next factor you want to think about is from the plaintiff's perspective. Is the plaintiff's interest, are they seeking relief that is proper, right? Here you're thinking about frivolous lawsuits, interference, stuff like that. When we're thinking about the plaintiff dragging the defendant into an inconvenient forum, similarly, how legitimate is the plaintiff's interest in this cause of action? Are they doing this for some sort of tortious interference reason, or are they doing this for legitimate redress? Related to that is the forum's interest. Does the forum state have a legitimate interest in providing redress, right? And those are going to be your three kind of main factors to think about when you're trying to discuss whether or not the exercise of general or specific jurisdiction offends traditional notions of fair play and substantial justice. But I'll put more factors below. The main thing to remember is Truthfully, this is one of those ideas that's being brought up by International Shoe, so you want to give the nod, you want to hit the buzzwords to let your grader know that you recognize International Shoe, that you recognize the importance of this idea of traditional notions of fair play and substantial justice, but at the same time, International Shoe didn't really give us a definable way to apply it, especially on a civil procedure essay. So there's going to be some grappling there, and courts have provided different factors and those things. Like I said, the main thing you want to look out for is blatantly wrongful conduct. Then you can think about it from the defendant's perspective, the plaintiff's perspective, and the forum's perspective, and make sure that nothing is offending traditional notions of fair play and substantial justice. But with that, guys, that wraps it up. So remember, your whole analysis when you're discussing whether or not the court has personal jurisdiction over the defendant. Number one, you start with the traditional basis. If any of the traditional bases are satisfied, court automatically has personal jurisdiction of the defendant. Either way, you're going to move on to state long-arm statute. If not, if none of the traditional bases are satisfied, no problem. Court can still reach out with the state long-arm statute and grab an out-of-state defendant, so long as minimum contacts exist between the defendant and the forum state. How do you determine whether minimum contacts exist? You got to run through general jurisdiction and specific jurisdiction. And then finally, once you've established that either general jurisdiction or specific jurisdiction might apply, just want to make sure that the exercise of such jurisdiction does not offend traditional notions of fair play and substantial justice. Sorry for the video cut there, guys. My camera is dying, had to restart it, but otherwise, I hope this video did make sense and that cut wasn't too bad for you. But otherwise, I wish you all the absolute best, and I'll see you at our next video.